Okay, this matter is now live on YouTube. Appearances have already been put on the record. Mr. Thomas is currently sitting on $150,000 cash bail. His attorneys have asked to be heard on bail. Go ahead.
Thank you. We are asking the court at this time to consider a cash bail in the amount of $2,500. I do realize that this is not a significant amount of money. However, it is a significant amount of money to this family, and this would be an amount that they would be pulling together. Unfortunately, COVID-19 has hit them very hard. Mr. Thomas, to his credit, does have extended family in Milwaukee County whom he'd be residing with, and they would be the ones who would help him with respect to posting the bond in this matter. Mr. Thomas was working as a real estate consultant after earning his real estate license back in 2017. He does indicate that he does believe that he has clients continuing to need his services with respect to his work, and that he does wish to get back to that work to assist his clients. He is certainly eager to have this matter resolved and would be compliant with any conditions that the court would put into place, but we are asking for the bond reduction at this time.
All right, Attorney Huebner, the state's position.
Well, I guess I'd like to know what has changed since the last time that we have done bail.
Well, as amongst other things, as counsel, I certainly don't know what arguments were made at the prior bail hearing. So this is all I have to work with at this point, and this is the information that I've received.
All right, so Attorney Huebner,
well,
your position?
Your Honor, I think bail should remain as it is. I don't see, and I understand counsel is saying that they're new, and I get that that might be a change, but I don't think it's a change in anything regarding what has already been determined here by several courts. In this case, Your Honor, it's a circumstantial case, but a fairly strong circumstantial case. I would note that the state was ready to proceed twice now for trial, and through no fault of the state's, we have not been able to proceed on those dates.
Can you refresh my memory as to what happened on those dates?
The first date, Your Honor, was scheduled to go for trial, and the court did not have a second court ready to go. I indicated I thought we could do this case in 1 week. Soon to be Judge Morales, if not already Judge Morales, indicated she did not think it would be able to be done in a week, and also had a appointment on Tuesday that was going to take up most of her Tuesday, if I'm not mistaken.
Yeah, you're right, correct. That was her judicial interview.
Yeah, no, I was not aware. I guessed it, but I wasn't 100% certain. So based on that, it was adjourned. And on the next date, since then, we've actually secured an additional witness through judicial means. The state was again ready to go, and the councils were not ready to go. I mean, and that's, again, it's not the state's fault. It's also not council's fault, because they would have literally had, I think, 12 days to get ready for such a trial. I would note, though, that one of the things that has changed in this situation is arguably the state's case has gotten better, since we now have a witness on bail, and the phone evidence and cell phone mapping that the state agreed that it was not going to use because it was turned over late before is now, we plan on using it, and it shows the defendant's cell phone hitting off of a cell phone tower that includes the area of the homicide during times consistent with what the video is showing. The defendant does have a criminal record. That criminal record includes, in 2011, 2 convictions, one for resisting and one for misdemeanor fleeing. That was amended down. In 2009, he has a armed robbery conviction for which he was sentenced to 2 years of initial confinement and 3 years of extended supervision. That extended supervision was later revoked in 2011 due to his fleeing case. In 2007, he has 3 convictions: resisting an officer, carrying a concealed weapon, and possession of a dangerous weapon by a minor. He received probation on that. That was revoked in 2009 due to the armed robbery conviction. There's a pattern here. In 2006, there was a battery, a juvenile adjudication that was dismissed and read into 3 convictions, and for which he was sent to Ethan Allen: possession of a dangerous weapon by a minor, possession of cocaine, and possession of marijuana, dismissed and read in.
All right, Attorney Huebner, that's enough. That's plenty.
Okay.
I know from spending many years at children's court, you don't go to Ethan Allen unless every other avenue has been exhausted. It looks like he was revoked at least twice, has at least 2 resistings, has been convicted of fleeing, is looking at extremely serious charges here. And the state's case has, unlike usual, has gotten better with time. So for all of those reasons, I think he is absolutely a flight risk. I think that the bail as set is appropriate. And so the motion to decrease his bail is denied.
Thank
And I
you.
think we have our dates, correct?
We do.
Yes, the next court date is February 25th of next year at 9 o'clock for final pretrial.
Okay, thank you, everyone.
Thank you.
Yeah, and hey,